Well, you all quieted down very nicely. I'm Jeremy Kellman. You may be expecting my colleague, Joanne Lynn, but she's now a happy backbencher. I am the reigning Associate Dean for Faculty Development, which means that I have the pleasure of introducing, actually not our speaker today, but my colleague Mike Murray, who's going to introduce our speaker. But I want to welcome you to the Tabor Institute. Many of you are familiar with it already. Every year we bring to Valparaiso Law a leading scholar in the field of legal ethics, broadly understood. I would love to say a few words about Professor Lubin, but I'm going to leave that to Michael. I'm going to tell you some other events that we have coming up this semester that may be of interest to you. I hope you all got the flyer. We're having a day-long conference on November 9th on drug sentencing. We have Randall Kennedy coming from Harvard University Law School as our luncheon speaker, and a big lineup of not just academics, but prosecutors, public defenders, clinicians, and some judges. So that will be a wonderful opportunity. And I believe through Melissa's good offices, we also have CLE credit for that. So those of you who are practicing attorneys might want to circle that date, November 9th, on your calendar. We also have this semester, November 30th, Brian Leiter from the University of Chicago, who will be delivering our annual Seekers Lecture. Brian Leiter is a leading legal theorist and one of the few people who can lay claim to the title public intellectual through his blogging activities. He's really actively engaged in public discourse beyond not only legal academy, but beyond the academy. So I hope you'll circle both those dates, November 9th and November 30th. We have some really wonderful events coming up this semester. And with that, Michael?
Good afternoon, ladies and gentlemen. A warm welcome to our speaker today and to our three panelists. And welcome to Dean Conason, my fellow faculty members, our distinguished alumni, and our guests. I have the honor this afternoon of introducing Stephen Lubet, who is the Williams Memorial Professor of Law at Northwestern University School of Law. He's director of the law school's award-winning Bartlett Center for Trial Advocacy. He teaches courses on legal ethics, trial advocacy, and narrative structures. He is the author of 15 books and over 100 articles on legal ethics, judicial ethics, and litigation. And he has also published widely in the areas of legal history, international criminal law, dispute resolution, and legal education. Some highlights of his book publishing career are the works John Brown's Spy, The Adventurous Life and Tragic Confession of Johnny Cook at Yale University Press, Fugitive Justice, Runaways, Rescuers, and Slavery on Trial at Harvard University Press, The Importance of Being Honest, How Lying, Secrecy, and Hypocrisy Collide with Truth in the Law at NYU Press, the intriguingly named Lawyer's Poker, 52 Lessons that Lawyers Can Learn from Card Players at Oxford University Press. I pause to note how nice it is that you spread out the wealth with all these university presses. It's very thoughtful of you.
Can't keep a job.
Another interesting title, Nothing But the Truth. Why trial lawyers don't, can't, and shouldn't have to tell the whole truth at NYU Press. Professor Lubet's textbook, Modern Trial Advocacy, now in its 4th edition, has been reviewed by a senior counsel of the New York County District Attorney's Office and, coincidentally, overheard by a fellow colleague at our faculty meeting yesterday as, and I quote, quite simply, it's the best book on trial advocacy ever written, period. And it has been widely adopted in law schools in the United States, Japan, Canada, Israel, the Republic of China, otherwise known as Taiwan, and the People's Republic of China and Chile. Professor Lubet is one of the foremost authorities on judicial ethics, the topic of his talk today, and is the co-author of Judicial Conduct and Ethics with James Alpini, Charles Gay, and Jeffrey Shaman, which has been called the nation's leading text on judicial ethics and which has been cited by numerous courts in over 40 state and federal jurisdictions. He has also written course texts that merge his interest and expertise in both lawyering skills and doctrinal law on the subjects of evidence, professional responsibility, trial advocacy, and arbitration advocacy. In addition to his scholarly writing, Professor Lubet's humor and opinion pieces have appeared frequently in the op-ed pages of newspapers, such as the Chicago Tribune, New York Times, San Francisco Chronicle, Baltimore Sun, Philadelphia Inquirer, Newsday, Los Angeles Times, and many others, as well as in the online journals Slate and Salon. His satirical commentaries have been heard on National Public Radio's Morning Edition. His Northwestern University faculty page reports that he was once interviewed by Stephen Colbert for a segment on The Daily Show, which is described on the website as being, quote, in the early days before they had famous guests. And so, without further ado, Professor Lubet.
Can you imagine? So I think Hillary Clinton is being interviewed by Stephen Colbert this week, and 10 years ago it was me. He's come a long way, and I'm still at Northwestern. Excuse me. This is my first visit to your university, but I have wanted to come here truly for over 50 years, and I will tell you the story. When I was in high school, probably a freshman or a sophomore in high school, my mother and father were very active in the civil rights movement on the south side of Chicago. And of course I came along with them. So we went, in those days, we marched with Dr. King and went to sit-ins and demonstrations. And there was a group of young men from Valparaiso who I thought at the time were graduate seminarians. I have since learned that there is no graduate seminary. So they may have been graduate theology students, or they may have been undergraduates, but one of them smoked a pipe, and I thought that was just the height of sophistication. Anyhow, these guys made a huge impression on me, really. Going back, it's been 50 years, they made a tremendous impression on me for their dedication to social justice and their idealism and their pipe smoking. So really, truly, I've always wondered what Valparaiso, it seemed like an iconic place to me, and I'm really emotionally very happy, to be able to join you today. Also, I'm very happy, very honored to give the Tabor Lecture. I don't know if Mr. Tabor is here. If you are here, thank you very much, sir, for endowing the Institute. And this does give me a tremendously fortunate opportunity to plug my new book. Because John Brown's Spy, the story of John E. Cook, who was one of Brown's chief lieutenants, takes place in part in the town of Tabor, Iowa. I don't know if Mr. Tabor is aware of Tabor, Iowa. It was a Quaker settlement filled with pacifists and abolitionists in the antebellum era, and one young woman who unfortunately became pregnant by John Cook, who then immediately decamped for Ohio. So if you want to learn more about him, you'll have to look at the book. And now I can proceed. Supreme Court ethics in the wake of NFIB versus Sebelius, also known as the Obamacare case. That is really the news hook for a longer and more complex story that I want to tell about Supreme Court ethics, or perhaps the absence thereof. As everybody knows, I think, who reads the newspapers, of course everybody knows who reads the newspapers, that Justice Roberts provided the fifth vote to uphold the individual mandate provision in the Affordable Care Act, also known as Obamacare. And immediately after he did that, there was a firestorm of controversy over leaks and counter leaks and intimations of favor trading and log rolling on the Supreme Court. And did Justice Roberts originally write a majority of a dissent, and it had become the majority where the dissenters were they really supposed to win? And various journalists, Dan Crawford and Jeffrey Toobin, apparently were obtaining inside information from somebody or somebodies on the U.S. Supreme Court, perhaps clerks, perhaps secretaries, but very likely justices. If you read the news stories, it seems pretty obvious that justices were complaining to journalists about the vote that the chief ultimately cast. Jan Crawford, by the way, started her career in Chicago at the Tribune. Jan Crawford specifically said that she was quoting two sources with specific knowledge of the deliberations. And of course, since nobody is present at the deliberations other than justices, the very strong implication is that somebody was talking out of court. So this raises what is, I think, an uncomfortable question. Did one or more Supreme Court justices do something unethical? Is leaking from the deliberations of the court unethical? And you might think that would be a simple question to answer. Anybody who's taken a professional responsibility course, would tell you that if you have confidential information and then you convey it to some third party, that's unethical, right? Everybody? Sure it is. And why do we know that? Because there's a model rules of professional conduct, and every lawyer has to follow it. And all you need to do is look at Rule 1.6, and there you go. You've got the answer. What is the comparable set of provisions that govern the Supreme Court? Well, there isn't one. We don't know what is or isn't ethical for the U.S. Supreme Court because, as it turns out, the U.S. Supreme Court is the only court in the United States, perhaps the only court in the world, that has not adopted a set of ethical standards. Now, there is, in the United States, as you probably know, a code of judicial conduct that has been adopted by every single state Supreme Court and all of the lower federal courts and any other court you can imagine that might sit somewhere in the U.S. This dates back to 1924. But the U.S. Supreme Court has steadfastly declined or refused all suggestions that they ought to announce some comparable code. This means, I think is going to surprise you, that there are no rules or articulated standards for the U.S. Supreme Court that cover issues such as confidentiality, ex parte communication, acceptance of gifts, political activity, charitable solicitation, certain sorts of financial disclosure, or outside speaking. Every other judge in the United States, and let me repeat that, every other judge in the United States can thumb through the model code of judicial conduct and find a provision that at least begins to answer those questions. Whether it's right or wrong, that's another issue. But every judge in the United States can do that, except the 9 justices of the U.S. Supreme Court. This has not gone unnoticed by critics of the court, some of whom, of course, are politically motivated and raise the issue only when they are unhappy with one or more of the justices. But in 2012, actually, a legislation is proposed in Congress by Congressman Murphy from Connecticut, who is now about to lose the Senate race to a wrestling executive. Not for this reason. So he proposed what was called the U.S. Supreme Court Transparency and Disclosure Act. That would have required the Supreme Court to adopt the code. Didn't say what the code had to include, just that they have one. And that, of course, met with stony silence at 1 First Street in Washington, D.C., but not quite stony silence. Not quite. Because Chief Justice Roberts, in his 2011 year-end report, issued surreptitiously on December the 31st, so that it would get minimal press. His words, not mine. Acknowledged the criticism. Justice Roberts acknowledged the criticism of this court that they did not have a code of conduct, but he said, don't worry, citizens. There is no reason for us to adopt a code. No reason for the U.S. Supreme Court to have a code of ethics, and he gave two reasons. Reason number one, a code cannot answer all ethical questions. Reason number one, a code cannot answer all ethical questions. And reason number two, no code can guarantee integrity. No code can guarantee integrity. Now, I see some of you chuckling at the obvious weak reasoning engaged by the Chief Justice. If you think that I am exaggerating, I urge you to look at his year-end report, because I have quoted it word for word. That's what he said. And this is really sort of strange, because Chief Justice Roberts has been called the premier advocate of his generation. Before he was on the court, he was supposed to have been a brilliant persuader. Now, we know actually that the premier Supreme Court advocate of that generation is Barry Sullivan. But those who don't know Barry tend to give that honor to Chief Justice Roberts. But somewhere he obviously lost his touch for advocacy. I guess when you are Chief Justice, you stop worrying about persuading people and simply assume that they will accept your word as law, but he did not reckon upon the Tabor Lecture as the antidote, as the absolute antidote to judicial hubris. So we see, I think it's obvious that the Chief's reasoning is not compelling. And just in case it isn't obvious, I will lay it out for you. Number one, code cannot answer all questions. Well, yes, that's right. But that's true of every court, right? It's not just the code can't answer all questions for the Supreme Court. A code could not answer all questions for the appellate courts, the state courts, the trial courts, and yet they all have codes. Code could not answer all questions for lawyers, and yet we operate with rules of professional conduct. Code could not answer all questions for seminarians, and yet we have the Ten Commandments. So it's obvious that argument is a make-weight, and the second one is worse. The second one is worse. It says no code can guarantee integrity. Well, that's true too. Of course, that's true. But we still have codes from sacred to mundane, none of which guarantee integrity, but at least they define integrity. We have the Ten Commandments, and we've got local plumbing codes, and we expect them to work as well as they're going to work. The Chief's argument, in case you missed it, is completely circular. In effect, he is saying the justices have so much integrity that they do not need a code, and if they had a code, they would probably violate it. Missing the point completely, I think, that a code of ethics, or just a statement of ethics, don't even need to call it a code, just a statement of ethics from the U.S. Supreme Court would define public expectations. We would know the standards that the justices set for themselves, and then at least in the realm of public opinion, we could know whether they are living up to reasonable expectations. For example, Justice Scalia has lately been on a book tour, pushing his latest book, which has sold a lot more copies than John Brown's Spy, I'll tell you that. pushing his book. And in the course of pushing his book, he has commented on matters that have come before his court and will obviously come before his court again. Now, somebody might think that's improper. Scalia clearly doesn't. But what do the other 8 justices think? I will tell you this. On the lower courts, there is a rule that says judges shall avoid commentary on matters that may come before their courts. Well, Scalia is out there talking about capital punishment and abortion and making his views clear. Obviously, those issues will be before his court again like that. And so it would be very handy, very helpful, very meaningful if the court would set a standard, whatever the standard is. Whatever the standard is. They could have a standard that says talk away, and then we would know. Or they could have the same standard as the other 20,000 judges in the United States, and they wouldn't talk away. And then we would know that. Of course, justices are aware of these criticisms, right? They address them from time to time. After the fact, right? So we never have an ex ante statement of standards or aspirations. Ex post, after the fact, the justices somehow always seem to say they did nothing wrong, right? They do sometimes remark upon the criticism, but it's always it's sort of stunning, isn't it, really, that no justice in the United States Supreme Court has ever done anything wrong, ever, in their own opinions. A statement in advance of standard and aspirations would create, at least in the realm of public opinion, some means of accountability, which is a proposition that the justices evidently regard with horror. Which brings us to the question of recusal and disqualification. Now, the issues I identified before, public commentary, charitable solicitation, receipt of gifts, those are important, and I don't want to minimize them. Disqualification, that is the decision about which justices will sit in particular cases. Recusal goes to the absolute heart of judgment, right? So you might say, well, we don't really want Supreme Court justices soliciting charitable contributions, because it's grubby, or because somebody might feel coerced, right? But that doesn't affect directly the quality of justice. But having a biased judge participate in a case does go directly to the heart of what it means to have an independent judicial system. So nothing is really more important. And yet, the justices have adopted what I call the code of silence when it comes to explaining their recusal decisions. When judges step aside from cases, as some do, when justices step aside from cases, as some do every term, they never explain it. It is a standard practice, and if you call as reporters do, if you call the Supreme Court Information Office, they won't explain it either. So, recently Justice Kennedy didn't participate in a case that involved the securities industry, and everybody went scrambling around wondering why did Justice Kennedy step away from the bench when the case was argued. And there's a lot of speculation about it, and some of that speculation is pretty good, but he has never said that. The rare exceptions occur when there is a formal motion to disqualify a justice, which happens seldom. And even less often than that, a justice may issue an opinion explaining why the motion is denied. That has happened exactly twice in my lifetime. Once in 1972, when then Associate Justice Rehnquist issued an opinion in Laird versus Tatum explaining why he was staying on the case. And again in 2004, the one you probably all remember, when Justice Scalia explained why duck hunting with Dick Cheney was just fine in the midst of litigation. At that rate, we can expect another explanation in 2036, when Professor Tillman may still be active, but I expect to be retired. Recently, just in the last term, there were a couple of non-recusals that begged for explanation. Justice Thomas and Justice Kagan were both, there was great discussion about whether Justice Thomas and Justice Kagan ought to sit in the Affordable Care Act case in an FIV versus Sebelius. It was suggested that because Justice Thomas's wife was so active politically in opposing the Affordable Care Act, that this could cause a reasonable person to question Justice Thomas's independence or impartiality in the case. And of course, Justice Kagan had been President Obama's Solicitor General at the very time when the litigation began. So those were both, I think, very fair and very serious questions about why these justices thought it was still permissible to sit in the case. Both did, of course, participate, and neither one explained why. Now, perhaps it was just fine for them to stay in the case. Right? Perhaps they had very good reasons. Perhaps they thought the whole thing through, and they reviewed all the literature, and they reviewed all the prior decisions, and maybe they talked it over with their colleagues. Maybe they even got independent counsel, as some justices have done in the past. Maybe they have very clear and concrete and well-reasoned rationale for staying in the case, but we'll never know because they don't address it. And for the life of me, I cannot figure out why. How would it diminish the court if the justices engaged in some level of transparency in explaining these tremendously controversial and important decisions? Now, we have two instances of explanation for the code of silence, again at 30-year intervals. So within the last couple of years, an anonymous justice told the journalist Tony Morrow that he didn't announce the reasons for his recusal rulings because he does not want to pressure his colleagues to think that they need to follow the same approach. And then in 1981, Justice Rehnquist sent a letter to the Des Moines Register who said that he doesn't tend to explain his recusal decisions, although he did 10 years earlier explain one, because his colleagues might disagree with him. And he didn't want to create dissent on the court on the subject of disqualification. So obviously, the justices are enshrining personal flexibility at the cost of public transparency, which at the very least I would suggest it shows disrespect for democracy. If you believe in any level of democratic governance, the public ought to be able to assess and evaluate the reasons that justices are taking the decisions that we do. Are we going till 3:30? And we'll take questions. So they're obviously valuing personal flexibility in a way that nobody else does. They don't hold press conferences. They don't take questions. They don't respond to reporters. And one other thing that they do is engage what we could call solo decision making. So you might think, okay, sometimes they disqualify themselves, and sometimes they don't. They don't give reasons, but maybe this is still the product of some sort of deliberation within the court. So maybe we can have at least some confidence that the justices, all of them, all 9 of them, agree that the decisions either not to sit or to sit are well thought through and well taken. But no, we know actually that they don't do that. We know that they don't do that. That the practice on the U.S. Supreme Court is to have each justice decide alone whether he or she will step aside in a case. And we know this because when the Sierra Club filed a motion to disqualify Justice Scalia in the duck hunting case. Yeah, it's funny just to say it, right? But, there it is, duck hunting case. When the Sierra Club filed the motion to disqualify Justice Scalia in the duck hunting case, the order that the court entered read, quote, the motion is referred to Justice Scalia, quote, in accordance with our historic practice. So not only are we doing it this time, but we've always done it that way, and apparently, by God, that's the way we're always going to do it. Each judge decides it alone. As Justice Breyer said in a recent congressional hearing, I have to make up my own mind. Nobody can do that for me. I have to make up my own mind. Nobody can do that for me. But obviously, we can't argue. That's the historic practice. That's what they say they do. I guess that's what they've always done. Just because they've always done it that way doesn't make it right. Probably that should be learned that first week in law school, I think. Just because we've always done it that way doesn't mean it's the right way to do it. And in fact, Congressman Murphy's bill in 2012 included a provision that would create a panel of retired justices to whom disqualification motions would be referred. So it was his suggestion, might be a good one or might not be, that when there is a formal motion to disqualify a justice, that instead of referring it to the affected justice himself or herself, that it would go to the senior most retired justice. I guess that would be Justice O'Connor, or if she doesn't want to do it, Justice Souter. But that's a pretty controversial provision, to have a non-Supreme Court justice disqualifying a Supreme Court justice. It sort of undermines the concept of what they call it. Oh yes, supreme. But there are alternatives. One that was suggested in the New York Times would be disqualification motions would be referred in the first instance to the Chief Justice, who, if thinking there might be merit, would then refer the motion to the full court. And then the other 8 justices, the majority of the other 8, could either disqualify their colleague or, obviously, most likely, deny the motion. So the more reasonable proposal, I think, was for review by the entire court. I think that's pretty reasonable. I'm betting most of you think that's pretty reasonable. But Justice Roberts, Chief Justice Roberts, did not think it was pretty reasonable. As we say in Chicago, it appears that the U.S. Supreme Court ain't ready for reform. Roberts again had his rationale. In fact, this time he had three reasons. That each justice should continue to decide personally and in complete privacy whether or not to participate in any particular case. Reason number one, other courts do not review the recusal decisions of their own members. So he said this is true at every level, that when a recusal motion is made or disqualification motion is made, it is made in the first instance to the affected judge, and then that decision is not reviewed, said Justice Roberts, by other judges in the same court. Reason number two, he said, was that full court review, and this is his words, would lead to the unfortunate appearance that the outcome of a case is being manipulated when the other justices decide who may or may not sit. So the reason not to refer disqualification to the full court is that it could give the appearance of manipulation, that justices are freezing somebody out in order to affect the outcome of the case. And then the third reason that he gave was what he called, quote, the unique circumstances of the U.S. Supreme Court, which required that recusals be engaged very sparingly, since there was nobody to substitute. In the district court, on the appellate courts, if one judge is disqualified, somebody else simply fills in, and the case proceeds with a full bench of one or three. In the U.S. Supreme Court, of course, if there is a disqualification, we go forward with only 8 justices, and that raises the possibility of a 4-4 tie. So that was the unique circumstance that Justice Roberts raised. And again, maybe it's not quite as apparent, but again, I think that the reasoning is very thin. Actually, that's putting it politely. The reasoning is very thin. First, he's just wrong about the other courts. I don't know who does his research. You know, he wasn't getting his clips from Valparaiso, I'll tell you that. Because, I mean, it took my assistant about an hour to find Michigan, Alaska, California, Oklahoma, and Texas. They all review disqualification motions at the same level of the court. You know, and she got tired. You know, there's probably more, but you know, after we found those, it just didn't seem necessary to keep looking. And in any event, one reason that lower courts wouldn't review disqualification at the same level is because they have appeals. Right? The idea isn't that disqualification should be unreviewable. The idea is if you're sitting on a district court and you make a mistake, well, that's why we have appellate courts. And disqualification or non-disqualification, rather, is reviewable by appeal or mandamus. So you don't need to review at the same time. And if the circuit court, you have the same thing. If the judge shouldn't sit, then that is reviewable by certiorari or, I suppose, mandamus, or probably even appeal as of right to the U.S. Supreme Court. So to the extent that lower courts don't sit in judgment of their lateral colleagues, it's because they don't need to. Because they don't need to. But Roberts comes to this very circular conclusion, where he says there's a previously unknown principle. It's never been identified before his hearing report. It's previously unknown principle that judges at the same level don't review each other's disqualifications. And then, well, surprise, we're at the top. So obviously there's no one to review us, and therefore we don't need to be reviewed. But then there's that other word, supreme. And as I recall, and I'm sure Chief Justice Roberts knows, the judicial power of the United States in Article 3 resides in one Supreme Court. One Supreme Court. That's where the judicial power resides. Not in 9 individual justices. Individual justices, I think, have no constitutional power. Or at least no guaranteed constitutional power. The power is given to the court. And so whatever the practice is in lower courts, provides, I think, no reason to avoid disqualification review by all non-justices, at least on those occasions where it is sought by a party, and perhaps where the Chief Justice thinks that the motion has at least some merit on its face. So then we come to Justice Roberts' second reason. You know, we could have done this with PowerPoint. And then there would be a slide, it's a tube, right? And I know how to use PowerPoint. But I was moved by Andy Borowitz's observation that PowerPoint was initially invented as a means to euthanize cattle. And he said it was abandoned for that purpose when it was determined to be less humane than the standard method of bludgeoning with a dull object. And so you don't really need to keep track of the numbers, but we are now on number 2. And reason number 2, I will again quote from the Chief's report. He said that if review were undertaken by the full court, this would lead to, quote, the undesirable situation in which the court could affect the outcome of a case by selecting who among its members may participate. The undesirable situation in which the court could affect the outcome of a case by selecting who among its members may participate. Now, let me say at the outset, I think the point of the court is to affect the outcome of the case. I mean, if you think your court is not affecting the outcome of the case, Chief, you ought to return the money, because that's your job, is to determine the outcome of the case. But you know, he's suggesting something sneakier there, some sort of chicanery, where a bunch of justices will gang up on another one in order to elbow him or her out of the case. But in order to realize that this cannot ever happen, you don't even need, you can keep one hand in your pocket and count on your fingers, right? 1, 2, 3, 4, 5. 5, right? 5 justices determine the outcome of the case. They don't need to disqualify anybody. If you have a majority of the court to decide the case in a particular way, there is no point to disqualifying a colleague, some other colleague, because he or she couldn't change the outcome anyhow. Why would 5 justices in the majority maliciously tell some 6th justice, what, you can't write a dissent? It would be pointless. This is this fear articulated by Justice Roberts. I am tempted to say it is like in-person voter fraud. It sounds scary, but it never happens. Or certainly it would never happen to the point of affecting the outcome of the case. But actually, the argument is weaker than that. The argument is actually weaker than that. This is an argument that Barry would never, even if requested by a client. He would draw the line. Justice Roberts assures us that each of his colleagues, and I'm going to quote again, is a jurist of, quote, exceptional integrity. We give it to the individual justices to decide. Don't worry. Each of my colleagues, he says, is a jurist of exceptional integrity, and I believe that. I'm not here to challenge anybody's integrity. I believe that absolutely. Each individual justice is a man or a woman of exceptional integrity. So here, what the Chief is telling us is that individually, one by one, these justices are absolute towers of uprightness and probity. But if you get 5 of them together, they're just going to sneak around and influence the outcomes of the case and manipulate their colleagues and do this horribly evil thing to squeeze somebody out for no good reason at all. Right? So each justice alone, well, you can trust them. But 5 together, look out, we've got trouble. Now, obviously, by sheer force of mathematics, and here I guess I could really use PowerPoint, right? Oh, wait a minute. Yeah.
There we go.
Right, the chances of one justice sneakily deciding to sit in a case inappropriately has got to be greater than the chance that 5, right, will collude to disqualify somebody else. So the argument again is circular, but more than being circular, it just completely misses the point. Just completely misses the point. And the point is not that anybody suggests or believes that a justice of the U.S. Supreme Court is engaging in some sort of disqualification shenanigans. Right? That nobody suggests that. Nobody believes that. Nobody thinks that happens with any ever at all. For example, I think most observers believe that Justice Scalia should not have participated in the Cheney case following. You know, I've talked to a lot of judges all the way across the political spectrum, and in confidence, unanimously, they have said to me that they think it was wrong and it was a bad example and shouldn't have done it, and it was not good for the judiciary. They all say this. I was on the phone actually the day before yesterday with a very prominent conservative judge on the lower court who said the same thing. But even I don't think, I shouldn't say even I don't think that Justice Scalia was intentionally trying to be unfair. I don't think there was some sort of chortling going on in chambers with the justice saying, ha ha ha, I'm really going to screw those guys. I'm going to decide intentionally in favor of my pal Cheney. I don't think he was insincere about it. I don't think he was trying to put one over on the public. I just think he was wrong. I just think he made a mistake. You know, the law, the statute calls for him to disqualify himself whenever there is, quote, a reasonable question about his impartiality. And I think he just made the wrong decision about that. And I think other justices would have made a better, or at least a more reliable decision about it. And for the same reason, I think it's just ridiculous to think that 5 justices would collude to exclude a 6th. I can't, I almost can't imagine a situation where that would happen. Except, of course, it did happen once. It did happen once. It wasn't really collusion. But at the very end of Justice Douglas's tenure, You know this, of course. So Justice William O. Douglas suffered a tremendously debilitating stroke, and in fact was pretty much incapable of reasoned thought at the very end of his career. He denied that he had had the stroke. This is a fairly common symptom of the type of episode he had. He denied that he had the stroke, even though he was completely paralyzed on one side of his body. He denied that he had the stroke and insisted that he was going mountain climbing. In fact, he insisted that he had gone mountain climbing, even though he told a very tragic story about a great and active man. And so 7 of the 8 other justices came to the decision that they would not issue any opinions, 5-4 opinions, in which Justice Douglas was in the majority for the balance of the year, the one additional year that he spent on the court. So they basically deprived him of his vote and set over for re-argument any case that was tied 4-4 without him. This only became apparent when 50 years later, 40 years later, the Supreme Court papers were revealed. But that's the one and only instance when any justice has, for some instrumental reason, sought to deprive another of the vote. And even that wasn't to influence the outcome of the case. In fact, it was the exact opposite, right? It was to ensure the integrity of the outcomes of cases. And I don't think it's fair or reasonable to suspect that any 5 justices in any combination you can think of who are sitting on the court today would act with any less integrity with regard to a colleague. So okay. So if I'm not worried about Justice Scalia's manipulation of his own vote, and I'm not. And if I'm not worried about 5 other justices trying to manipulate outcomes, and I'm not, and I hope you aren't, why am I so concerned about solo decision-making? Right? What's the problem? And the problem with it, the real problem with it, is the absolute cognitive impossibility of recognizing one's own biases. This is. I'm not saying it's hard. I'm saying it's impossible, right, for an individual to be fully aware of his or her own biases. And there is a mountain of science behind this conclusion, an absolute mountain of science, none of which was conducted for the purpose of disqualifying Supreme Court justices. You know, these are people who use functional MRI machines to do brain scans about recognition skills. They couldn't name a Supreme Court justice or something. But you know, they really don't care about judicial disqualification. But there is study after study and book after book by people like Dan Kahneman, Nobel, the only cognitive psychologist who's ever won the Nobel Prize for economics. Really, the cognition science is absolutely unanimous to, as Kahneman put it, that you should not trust yourself to tell you how much to trust your own judgment. Because you can't. Or the British cognition scientist, Holly Charot, refers to what she calls the introspection illusion, that you might think that you are in touch with your own biases, but you aren't. It's an illusion. There is a level of bias that operates in a way that is completely unknown to you, and that you cannot make yourself aware of. And there's popular literature from psychologists like Jonathan Haidt and linguists like Steven Pinker psychologists like Dan Gilbert or physicians. It's a huge problem for physicians. They talk about cognition errors, where physicians are unknowingly biased in favor or against particular diagnosis. And the only remedy to it is to have somebody else look at the case. Because, even those who are scientifically trained cannot overcome biases of which they are unaware. Although apparently the Supreme Court justices think they are immune to this problem, with one exception, that having been Justice Felix Frankfurter, who in the law of the 1940s case, Public Utilities versus Pollock, admitted that he could not tell whether he was biased or not with regard to the playing of music on the public buses of Washington, D.C., and so he disqualified himself from the case. Interestingly enough, the Supreme Court justices do recognize this problem when it comes to lower court sentences. And just 2 or 3 terms ago, in Caperton versus Massey Energy, where they reversed the judgment of the West Virginia Supreme Court, and Justice Kennedy, in the majority, said that it is not unusual that a judge will, quote, misapprehend the real motives at work in deciding the case. And of course that's true, right? No matter how much you might think, how much a judge might think he or she is deciding the case on the basis of law and evidence, there is the inevitable risk that you will misapprehend the real motives. And I can pretty much prove this to you. Pretty much I can prove this. In fact, I will prove it. So here's what I would like to do. And don't worry, I'm not going to call it. Think of a time that you did something really embarrassing that you would not like to share with the rest of us. Could you please do that? Get that firmly in mind. Do you have something in mind? Okay, all right. Don't worry. Barry, you have something? Yeah, did it happen in class? Don't say it. All right. Yeah. So you got something firmly in mind. You did something really embarrassing. Now ask yourself, what were you thinking? Right? And I'm certain the answer is I've got no idea how could I have possibly been, right? Because you cannot recreate the motive that led you to do something that you now think was foolish or embarrassing or regretful, or speaking of my generation, illegal. Young people today much more law-abiding than we were. So they recognize this, right? For everybody else in the world, except themselves. Everybody in the world is held to one standard. Justices of the United States Supreme Court hold themselves to another standard. When I put my notes together, Jeremy, I knew that this was going to be an hour and a half. And I made the mistake of evaluating my notes on Indiana time. and failed to realize that Chicago time moves a little more quickly, so we may be done a bit early. Good, he says. As soon as possible. But not yet. The poetic case, of course, is even stronger than the scientific case and has been well known since the 17th century. To quote Robert Burns, "Would some power the gifty give us to see ourselves as others see us?" And then the seldom quoted third line, which is even more appropriate to the justices. "It would, fray many, a blunder free us." And by the way, you've all heard that, some version of that quote before. It is from a poem called To a Louse. I'll leave that hanging for you. An excellent example of this problem, and a recent one, is Justice Kagan's involvement in NFIB versus Stevens. And I use this example, I think it's important that I use this example, because as you may have guessed, I tend to like and agree with Justice Kagan. I tend to disagree with Justice Scalia. When it comes to disqualification, they are identical. They follow the same rule of non-announcement, by and large. They take the decision solely to themselves, and we are left mostly to guess. Justice Thomas, for sure. Justice Thomas and Justice Kagan took the identical approach to disqualification in the Affordable Care Act case, but Justice Kagan was worse. Justice Kagan was worse. And here's why I say that. For Justice Thomas, people are saying he should disqualify himself because his wife was a highly involved political actor in the policy arguments against the Affordable Care Act. And one would imagine, if you had the opportunity to interrogate or depose Justice Thomas on this issue, he would say, well, my wife has her views and I have mine, and we don't talk about cases, and I'm not influenced by what she does. And we know Justice Thomas would say that because that's exactly what Judge Reinhardt said on the Ninth Circuit when it was suggested that he should disqualify himself from the same-sex marriage case, the Proposition 8 case in California. Justice Reinhardt, at the time, was married to a woman named Ramona Ripson, and she was the executive director of the ACLU, the American Civil Liberties Union of Southern California. And they had filed an amicus brief in the case. And this is a motion to disqualify Justice Reinhardt, which the Ninth Circuit referred exclusively to Justice Reinhardt, citing the U.S. Supreme Court. And Reinhardt said, well, my wife's politics are her politics, and my judgment is my judgment, and it's insulting, he said. I don't think it really was, but he's very good at taking umbrage, if you know Judge Reinhardt. So he said, it's irrelevant what my wife thinks to my judgment. I make my own decisions, and she makes hers. So we know, I think, with great confidence, that this is what Justice Thomas would say if he were called upon to explain his identical decision. I think they would both be wrong, but that would be the explanation. Justice Kagan's situation, however, is very different. Justice Kagan was the Solicitor General of the United States, the boss, right? Was the Solicitor General of the United States at the time that the litigation over the Affordable Care Act was beginning. And it appears that she had some clue that she might be nominated to the U.S. Supreme Court because she isolated herself, or she says she isolated herself, from anything that had anything to do with the Affordable Care Act. So even though she was the Solicitor General, who usually signs all the briefs, and who is usually involved in all of the strategy decisions, apparently when it came to the Affordable Care Act, and even though she was Solicitor General, she walled herself off from all of the litigation, or so it has been said. Or so it has been said. But the fact is, we don't know, right? Because Justice Kagan has never explained it, right? We are left to intuit from documents that were produced to the House Judiciary that she created this wall between herself and the Affordable Care Act. But let's assume she did. Let's assume she did. There was a wall. She had nothing to do with it. How do we know the wall was accurate, was sufficient? How do we know the law was adequate? Well, we don't, right? And who is the only person who has reviewed the adequacy of the law? The one and only person in the whole United States who has had a definitive review of the adequacy of Justice Kagan's precautions was Justice Kagan. I have reviewed my actions and I find them beyond reproach, says Justice Kagan. Well, this is problematic, to say the least. And I think you would find in no other profession that the person who created the precautions would have the final word about their sufficiency. If you need surgery and the surgeon says, "Don't worry, I will double check everything myself," you need a different doctor. If you were to get on an airplane and the pilot were to say, "We don't need a co-pilot for this flight. I will do all of the safety checks twice," you should either leave the plane or take a parachute. Even law review editors, don't do their own site checking. I mean, it is troubling to say the least. And I say this with great respect for Justice Kagan. We have a lot of mutual friends. It is troubling to say the least that she would sit in sole judgment of her own safety matters. So this brings us to Justice Roberts. If you've been counting, we're now up to the third and final rationale of Chief Justice Roberts, where he says that there are, remember, unique circumstances. Did anybody take that now? Unique circumstances. Circumstances unique to the Supreme Court. That justice cannot be replaced. This is sometimes called the duty to sit. That a justice cannot be replaced, and therefore we need to minimize disqualification. This is a non sequitur. Remember, the proposal is that justices should not decide disqualification themselves, but the full court should decide it. And the answer is, oh no, that would lead to too much disqualification, or could lead to too much disqualification. Well, he's conceding then that the other 8 justices might disagree with the first one, right? Because if they agreed, there would be no more disqualification. So it's implicit in his whole argument that the first justice might now and then get it wrong. Well, if the first justice gets it wrong, why do we want that person sitting? Just to avoid an 4-4 tie? Wouldn't we rather get rid of the biased justice? Especially if the other 8 thought that what she was doing was wrong? And yet, this argument recurs multiple times. So Roberts says that it's unique to the circumstances of the Supreme Court that we need to minimize recusal. Justice Breyer said that we don't want frequent recusal because it could change the outcome of the case. Justice Scalia says that even the unnecessary disqualification of even one justice, quote, impairs the function of the court. Impairs the function of the court, says Justice Scalia. But, as I said, you have to ask yourself, if the single judge is getting it wrong and 5 others think he or she shouldn't sit, isn't that better than proceeding with a full court? But you know what? Put that aside. Forget the non-sequitur. Assume that it makes sense, which is what we often have to do with Supreme Court decisions. Assume that it makes sense. It's still not a problem. It's still not a problem because these dreaded 4-4 ties, the ones that should influence everything we do about recusal on the Supreme Court, these horrific no good, terrible, very bad, awful 4-to-4 ties almost never happen. Even when there's 8 justices sitting, the 4-to-4 ties almost never happen. In one study from the period 1946 to 2003, right? So that's almost 60 years, 57 years. There were 600 cases decided by 8 justice courts, of which 49, fewer than 1 out of 12, ended up in 4-to-4 ties. In Justice Kagan's first term, where because she had been SG, she disqualified herself 28 times. Only 2 of those cases ended up in 4-to-4 ties. Basically, 1 out of 12, 1 out of 14. So, if the referral to the full court resulted in the disqualification of 1 justice per term, which I think is about the most anybody imagines it could be, 1 more 8 justice court per term, it would affect the outcome of 1 case every 12 to 14 years. Even at today's slow rate, the court decides about 80 cases a year, so that would affect about 1 out of 1,000 cases, 1/10 of 1%. And that's generous. That would be the consequence of a situation where the full court were to decide recusal motions. And with that, I think we can take some questions and then go on to Ken. How's that?
Sure. The court as a purely political institution, just like Congress. And it would be very rare, indeed, for a congressman or a senator to say, because this legislation might affect me personally or because it might affect my friends, I'm going to recuse myself from voting on that legislation. And in fact, from a partisan perspective, for example, if I were a Democrat, I'm not saying anyone, I would be extremely disappointed in my congressman or senator for doing that. And the Supreme Court is unique among the judicial institutions in that the cases that it hears tend to be much more politically charged, and the kinds of things of subject matter that people political disagreements about. Exhibit A is the Obamacare, is the Great Affordable Care Act. And so from a partisan political perspective, we, Democrats, would be really disappointed in Justice Kagan for recusing herself. So look, I guess I'm just challenging you.
I think you're completely right. And the more political one regards the court to be, the less one cares about the biases of justices. And if one thinks the court is exclusively political, then one wouldn't care at all. There is this problem with the statute that provides to the contrary, right? I mean, you would from time to time think, law and courts, and have a certain expectation. So 28 U.S.C. Section 455, which I should have cited earlier, does call for justices to disqualify themselves under those circumstances. And so the question isn't whether they will disqualify themselves, but where the locus of the decision would be. And I maintain that the more reliable decision would come from a majority of the court rather than from the individual member. And that's a purely positive argument. I think the decision would be better. I don't really care how it comes out. I just think it would be cognitively more reliable if it were shared by more people. And there's a lot of science about that, right? That group decisions, group sourcing is a preferable way to make this sort of decision. And by the way, some legislatures do have rules about not voting on things where at least where your personal interests are at stake. And this is going to get a big laugh, but in Illinois, that's a crime. Not that, what can I say? Yes?
I want to go a bit the other way, the non-political direction. And as you know, our Supreme Court has moved in its history toward a position where finally in 1958 it claimed judicial supremacy over the Constitution. Its word was equivalent to the Constitution against the wishes earlier on Jefferson and Jackson and Lincoln and Calhoun. Now, is there any way in which that position of judicial supremacy, of non-reviewability, you know, the kind of kingly absolute power personification that the court and the members of the court would be harmed by any sort of ethical scrutiny or any of this, you know, forcing somebody to go off, that they would see this right? Our absolute monarchy might be generated into a constitutional monarchy. It might be under the Constitution if they go through this Constitution.
Well, I think that's your territory, Jeremy, isn't it? Well, first let me say that I do not share Calhoun's constitutional vision, and I wouldn't care, I think, if his views, which were pretty much repudiated by the Civil War, were disregarded. I think that there has been an arrogation of power. Whether that's a good thing or a bad thing in large policy terms is, as Congressman Henry Hyde once said, above my pay grade. But there's also been an arrogation of power in personal and individual terms. So if you think of the sort of regal trappings of the justices, I think that's not a good thing. And this would be a small curative in that regard. Barry, whom we're going to hear from in a few minutes, told the story of a visit to his campus at Washington and Lee by Justice Thomas, right? And how the U.S. Marshals first came, and this is true of every justice, how the U.S. Marshals first come days before, right, and check out every place the justice is going to be. Many years ago, Justice Blackmun came to our campus, and I had the job of introducing him. So we spoke for a few minutes. And, he told the story of how he can't go anywhere without marshals in the advance and check them all out. But until the 1890s, post-Calhoun, until the 1890s, the Supreme Court justices still rode the circuit, and they traveled probably by themselves or just with one other person. So there certainly has been a removal of the justices, and some of that's inevitable. Justice Blackmun got a lot of death threats following Roe versus Wade. He needed the body guards, but some of that's inevitable, but some of it's regrettable. Yeah, John.
So I know your research assistant was probably pretty exhausted after canvassing all of these states, as you said. But I was wondering.
Well, you notice I co-authored it's co-authored on the paper, so she has been rewarded. I could have paid her, I suppose.
I was wondering if you, by any chance, looked at different rates of recusal in different jurisdictions. I guess what I would suspect is that there's probably fairly high rates of filing recusal motions or motions seeking recusal in jurisdictions that have sort of more what you would characterize as equitable processes relative to the Supreme Court.
Yeah, that's
so,
it. No, I mean, it's a great idea. My research assistant has graduated, but that's a good idea. It'd be pretty hard to figure out what the baseline is, and certainly at the trial court level, one would never know.
Because I guess my experience just from practicing at the trial court level is it happens probably much more frequently than I would guess in the Supreme Court. And I suspect, I thought your debunking of Justice Roberts' three reasons were really great, but I suspect that what's really operating below the surface was his sense that he doesn't want a lot of people bringing these motions. And the reality is that the stakes are so high in these cases that people would bring a motion in every single case, basically, if there was a sort of transparent process that was out there and involved the entire court
think? I mean, one might assume that, so I don't know if you heard that. He said that if there were a transparent process, perhaps the court would be flooded with disqualification motions. Perhaps the court would be flooded with disqualification motions. But one might imagine that people would continue to be reticent. If you strike at the king, you must kill him. And I don't think there would be. I don't think the motions would be more successful if decided by the full court, other than on rare occasions. So I don't know if that would encourage more.
Maybe people would be trying to recuse Justice Kennedy, but they would be going after the other ones who it's obvious which way they're going to come out anyway.
Perhaps. I don't know if that would be bad. I guess people might get tired after they keep getting turned down. The other advantage, by the way, of doing away with the solo decision-making accompanied by lack of explanation, if we were to do away with that, then there would be a body of law, which we don't have. So if the court got into the habit of deciding these cases, like regular motions, and explaining why they either did or didn't disqualify, then one would guide it, just like in any other circumstance, by a body of law. I think that alone would be salutary. I see that.
I think we should probably give people some time to stretch their legs. Join me in thanking Professor Lubin.